Good morning, good morning, good morning. It's Tuesday, it's August 20th. I can't even believe the time has passed that fast. And yes, I'm a bit under the weather, so I'm sure you can hear it in my voice. It just is, it is what it is, and we're doing what we're doing what we're doing. We're doing the things. The voice is what the voice is. I traveled last week. I am definitely sick this week. We'll just see how the week goes. I have a new podcast for you tomorrow, so stay tuned in the Law Nerd app for that. I break down the indictments with regard to Matthew Perry, and I break down all of the indictments. So I go through the 3 cooperating defendants and then the 2 main indicted defendants. So it's really 2 indictments and 3 informations, but that's probably deeper legally nerdiness than you need. So today we're going to just talk all things Murdaugh. I have another story that I haven't really seen covered anywhere. I found it with Law 360 and I wanted to talk about it. So we're going to talk about that too. I've got some coffee. We're going to plow through. We're going to talk about Murdaugh, and that's really going to be about it today. Got to be honest. We'll get into some more topics on Thursday. I have tried to keep the nose clear so that it doesn't sound awful to all of you listening with headphones. I will continue to do my best, but I didn't want to miss another stream. I have the runway to be able to just nap again after stream, so hang in there, and thank you for letting me hang in there. And it just is. It's the fall. It was so funny because, well, coffee. The coffee is good. The coffee is coffeeing. Went to get medication yesterday and looked at them and I'm like, hey, so it's the fall. I traveled, which means I probably have COVID. So can we just do a COVID test and do the Paxlovid, whatever, because that's where it's at. Like, it's fall. I worked the county fair. We picked up shifts because so many people were down, because it's that time of year where it's just like whoosh, it's going around. So it has gone around, but I will be feeling better. So for all of you that are under the weather, I get it. It is just wild. Vicky, I know I say this in tomorrow's podcast too. It's August, it's not fall. Here's why it's fall in my brain. And I'm not saying you're wrong, Vicky. I hope it's still summer for you. I want it to be summer for all of you. It's fall for me. Why is it fall for me? My kids are in school. Band camp is over. Football games start, and Starbucks is releasing its pumpkin spice like this week or next week. Hold on. God, maybe it's today. I don't even know. Today's like Double Stars Day. That's not happening. Let's see. Starbucks pumpkin pumpkin spice 2024. It normally comes out like the last week of August, and it's funny because I've seen like the pumpkin spice wars, like the basic bitch wars of all of it. So the basic bitch wars are every single other coffee outlet trying to release pumpkin spice before Starbucks. So it's everywhere. You go to a Dunkin', pumpkin spice. You go to anywhere else, it's pumpkin spice. Starbucks rolled out the fall menu August 23rd last year, and it looks like it's going to be August 22nd this year, though the latest rumored date is August 27th. I'm probably guessing that it's going to be Thursday. So it's fall to me. This is why it's fall to me. The leaves are starting to fall off the trees, but then there's still hot days. It's fall to me. So everybody's got their pumpkin spice out, trying to get ahead of the pumpkin spice that is Starbucks. It just is what it is. So that's why it feels like fall to me. Please, if it's summer for you, lean in, like lean into your summer. Lean in. If you have the last days of summer, please lean into it like 150%. All right. With all of that, we've got some stories to talk about today. The headline that we're going to get to, quick bits, but not really, but yes, is the Brazen plot to steal Graceland. We're going to talk about somebody trying to steal Graceland from the Presley estate. Yes, sort of music law, but not really, but kind of, but sort of. But the headline, I was like, oh, Brazen. Once you get the Brazen in there, I'm in. Murdaugh is trying to like appeal his federal sentence. If we want to talk about that, I'll put up a poll. We'll talk about it too. But of course, we're going to talk about the Supreme Court taking up its case. what that means, what it doesn't mean, all the rest of it, because I've seen a lot of information out there. Not all of it's accurate. And we need to go through it. Like we're gonna go through it anyway, but we need to go through it. But first we're gonna talk about Graceland. Because what in the world? Who tries to steal Graceland? Also, I did prosecute a house, like a stolen house case. It was wild. So I stopped reading after that headline and I'm like, we're covering this together because I'm fascinated and the law nerds are coming with me. So mount up and ride. It's Tuesday. Hang in there, everybody. Hopefully your coffee is coffeeing, or depending on where you're watching this and when, whatever you are drinking. The water is hydrating. The whiskey is whiskeying. The coffee is coffeeing. Let's roll.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Right. I forgot to change my chat from top chat to live chat. The number of people I have said to that work at YouTube, like, hey, can we default to all? And if we want less than all, let us like select out. And they're like, yeah. And I'm like, but can we please do that like immediately? It would be so helpful. It would be so helpful. So replay crew, love you. I'm going to go little hearts because my hand has coffee. All the timestamps will be down below. So you'll have all of that. Members, I'm going to have to move the members only live stream because I have got to sleep and not be sick. So we're going to bump it because I want to tell you all the things about going to Boston and being on morning radio in studio and seeing New Kids on the Block and all things Mix 104. And we have other things to talk about, but we've got lots to talk about our members, but I can't do it if I am look, I've got like a window right now, and that's it for the day. So we're going to bump our members till next week. Bump. Don't worry. We will get to it. I don't want to just pop it onto the calendar, like later this week and surprise you guys. It's going to be, so we'll move it to Wednesday next week. I know. I see all you guys saying we understand. I know. It's going to be good. We're going to be fine. It's all going to be fine. So let's get through this brazen plot to steal Graceland. I'm fascinated. And I haven't seen this covered. I'm really glad that Law 360 covered it because I was like, what is happening? So let me try to make this a little bit bigger. We're going to look at the charges too because it's here. I'm going to try to make that big enough for you to read on your screen, no matter what size your screen is, no matter where you're watching from. There we go. Brazen plot to steal Graceland from Presleys nets charges. So people have been charged with this. This is from August 16th. A woman was charged in Missouri Federal Court Friday with attempting a wild scheme to defraud the family of Elvis Presley by auctioning the late singer's iconic Graceland estate and pocketing the proceeds, a plot that was only foiled when suspicious minds raised red flags. Look, there are so many frauds, and there are so many that fall victim to fraud schemes and then blame themselves and then don't tell anyone, don't talk about it. So red flags can't be raised. If something sounds odd, you have to talk to someone. Like, this is where I get phone calls from my mom all the time. Like, I got this pop-up on my computer and I'm pretty sure they're trying to steal everything. My mom is the most suspicious mind when it comes to not clicking anything. And I'm like, okay, that's an Apple update and eventually you're going to have to click it, but you don't have to do it right now if you don't have time to update everything. I would rather she call me about every single pop-up, email link, everything. Don't click the link. Don't do the things. It's wild. My dad, on the other hand, is not always suspicious enough. It goes on to say, Lisa Janine Fidley of Missouri, who prosecutors say has several aliases, and then it lists all of them, both female and typically male named aliases, was charged with identity theft and mail fraud. Look, sometimes when you need a fake identity, you can't be choosy. Sometimes you're just like, whatever. But I imagine, because there are some of these with similar last names, Gregory and Kurt Nusany, Naussany. I wonder if those are stolen identities of someone that this individual knows, right? These are not just like aliases. These are truly stolen identities. It says the alleged plot involved Fiddley submitting forged documents to the Presley family and the courts purporting that her company loaned Elvis Presley's late daughter, Lisa Marie, millions of dollars with Graceland in Memphis put up as collateral. What? According to prosecutors, the case was charged in the Western District of Missouri, where the alleged accused is redundant, where the accused resides, with federal prosecutors from Tennessee and the United States Department of Justice Criminal Division prosecuting the case, along with significant assistance from the U.S. Attorney's Office for the Western District of Missouri. So multiple jurisdictions involved. You know Tennessee's pissed. They're like, leave Graceland alone. Like, don't mess with Elvis. Don't mess with Dolly. Like, leave it be. Leave it be. As part of a brazen scheme, look, you use brazen, the headline's probably going to grab my attention. As part of a brazen scheme, we allege that the defendant created numerous false documentations and sought to extort a settlement from the Presley family, says the head of the DOJ Criminal Division on Friday. She is now facing federal charges. The criminal division and its partners are committed to holding fraudsters to account. Absolutely wild. In the charging document, the DOJ laid out the history of the Graceland estate, which was purchased in 1957 by Elvis Presley, the rock and roll icon known for the Wait, we're explaining who Elvis Presley is? I guess that's right. I'm old. I guess not everybody knows who Elvis Presley is anymore. But okay. The rock and roll icon known for his classic hits, Heartbreak Hotel, Suspicious Mind. Come on. You don't list Jailhouse Rock. Come on. We're talking about a criminal complaint. It's such a missed opportunity. It's such a missed opportunity. It's such a missed opportunity. And Jailhouse Rock, I'm adding it. After he died in 1977, the property passed to his family and then to his only child, Lisa Marie, often referred to as LMP in the criminal complaint, Lisa Marie Presley. Chat's like, what about Hound Dog? You're exactly right, chat. Oh, keep throwing Elvis songs in there. I'm here for all of it. It was passed to Lisa Marie Presley, referred to as LMP in the criminal complaint, through a revocable trust established in 1993. The Graceland property reports receiving hundreds of thousands of visitors a year. I believe it. When Lisa Marie died in January 2023, her only surviving child, Danielle Riley Keough, referred to as DRK in the criminal complaint, became the sole trustee and sole owner of the property, although the criminal complaint makes references to the alleged plot being an attempt to defraud the Presley family. It is an attempt to defraud the Presley family through the surviving family member, but you lose your mom and then you've got people coming out of the woodwork trying to steal your shit. It's not okay. But when people are grieving, it's one of the things that can make people incredibly vulnerable. It's like, oh, you've got to deal with this. You've got to deal with that. I've had friends reach out to me years after parents have passed, like, hey, I got this notice from the bank. Does this even seem legit? These things can be difficult to deal with. It's like adulting to have to deal with grieving, to have to deal with properties, to have to deal with estates, to know what you have to deal with to clear estates and title. It's a lot. It's absolutely a lot. It just goes on to say, using multiple identities, email addresses, and forged documents, the accused attempted to convince the Presley family that a fictitious company named, what was the one in Seinfeld? What was the fake company with the fake boss from George Costanza? And he was like, no, it's this. Anyway, a fictitious company named Newsony Investments and Private Lending LLC loaned Lisa Marie $3.8 million. Thank you, Vandalay. Vandalay Industries. Thank you, chat. You guys nailed it. Vandalay, Art Vandalay from Vandalay Industries. Get it. Chris, we were so close. This is where I was stuck. I was stuck with Mandalay Bay. Vandalay from Vandalay Industries. Thank you, chat. You guys are the best. Yes, it's the same, right? Vandalay Industries. So this fake investment company and private lending LLC, they say had loaned Lisa Marie $3.8 million in 2018, and she pledged Graceland as collateral, but defaulted on the payments according to the criminal complaint. The accused allegedly sought $2.85 million from the Presley family to settle the loan, and she also filed a false creditor's claim with the Superior Court of Los Angeles and a fake deed of trust with the Shelby County Registrar's Office in Memphis, according to the complaint. They're lucky she didn't also file like a quit claim deed or lien against the property, but you know. The accused also allegedly published a fraudulent foreclosure notice in a Memphis newspaper while announcing that the investment company would auction Graceland to the highest bidder on May 23rd. Stop right there. The audacity. The audacity. When the Presley family sued the company in Tennessee state court to stop the sale, the accused submitted false documents to the court according to the criminal complaint. Oh, it gets worse. It gets worse. This is ongoing. I was like, how did we get to a criminal complaint? Well, this is how. This is how. They sued to stop her, and then she submitted more fake documents to the court. Good. Keep going. Just keep going. Just keep going. So wild. When the attempt to auction Graceland received media attention, I mean, are you shocked that it received media attention? You're trying to auction off Graceland and you think no one's gonna notice? I mean, what? I've got to turn my fan on. Why? Because I was cold earlier and now I'm hot. That's just, we have no body regulation at the moment. Why? Because we're sick. Wait a sec. Chat. I'm going to admit this to you because I trust you. Hold on. I just tried to turn my fan on with the remote control for my third monitor. This is the remote for my third monitor. This is the remote for my fan. And oh, y'all. Emily, girl, get it together. It's all fine. Everything's fine. Everything's great. We're fine. Everything's fine. It goes on to say, when the attempt to auction Graceland received media attention, the accused wrote to the Presleys representatives, the media, and the Tennessee state court, falsely claiming that the person behind the plot was an identity thief in Nigeria, according to the criminal complaint. Oh, so now you're just going to try to blame it on somebody else. Somebody who's like, I work for a prince. Good Lord. It's like, no. It's someone out of the country. Stop it. Stop it. I don't know how to pronounce this word. As a Memphian, I know that Graceland is a national treasure, says the U.S. Attorney Kevin Ritz for the Western District of Tennessee in a statement. This defendant allegedly used a brazen scheme to try to defraud the Presley family of their interest in the singularly important landmark. Of course, all homeowners deserve to have their property protected from fraud, and the DOJ will vigorously prosecute anyone who commits financial crimes or identity theft. It's going to just be more popular. It's going to be more newsworthy when you are, in fact, trying to defraud the Presleys of Graceland. How do you think no one would notice? How do you think no one would notice? These U.S. attorneys are picking one word and sticking with it. It's kind of like when people get stuck in my brain has stopped. The lavish lifestyle. Once you put lavish lifestyle in something, you continue to go forward. Let's see. The accused is scheduled to make an appearance in the Western District of Missouri on Friday, the Department of Justice said, and then it lists out the attorneys from the U.S. Attorney's Office. Look, you've got fraudulent documents. You've got a plot to steal Graceland. What else do you need? What else do you need? We're going to take a look real quick at the complaint. Oh, I've got to do it a different way. Hold on. We're going to take a look real quick at the complaint to just see what, no, not yet, to see what else is there. And then we're going to move on and talk all things Murdacity. So it's just going to be a slow going day until my brain recovers from me being sick. So this is from the Western District of Tennessee. I wonder if we also have the one from Missouri. I'm going to have to go find the Missouri one because now I'm deeply invested. I don't know about y'all, but I'm invested. I'm invested. Let me know if you're invested. I just want to keep, we'll keep an eye on it to see what happens. Ned in the chat said they're going to be stopping at the Heartbreak Hotel. Absolutely. The Graceland heist would make a great movie title. I mean, you could Ocean's 11. It's wild. So Sandy White said the Graceland thing is old news. It happened Friday. So yeah, it's old news because it happened on Friday. It's Tuesday. So the criminal charges are just about as new as we get up in here. So Sandy, don't worry. We're going to get to, and I think you meant Alex, but we're going to get to Alec Murdaugh in just a minute. We're talking about Graceland. It's all right. It'll be time-stamped. So let's go through this affidavit from August 15th. What is unsealed on the 16th. Affidavit in support for application of warrant. The FBI is involved. Oh, well, that's always a good day.
The FBI!
I am a special agent with the FBI and have been so employed since September 2016.
The FBI!
I am currently assigned to the FBI field office in Memphis, Tennessee. This goes through all of their affidavit. I don't want the affidavit. What I want is, I'm going to have to go grab all the stuff from Missouri. I was very excited that we might have more here. We do not. We do not have more here, but that's okay. Aggravated identity theft and mail fraud. I bet they could tack on more. So this is the PCA to go arrest before they took the accused to Missouri on the aggravated identity theft. Using a series of aliases, email addresses, fake documents, the accused engaged in a scheme to defraud Elvis Presley's family for millions of dollars by threatening to foreclose on the Graceland estate owned by Mr. Presley's family and auction Graceland to the highest bidder as part of a fraudulent non-judicial sale scheduled for May 23rd, 2024. And then they list the fraud to the scheme to defraud and all of... Look, man, when it's like the at Hotmail... Let's first take a look at the email addresses. Not the Hotmail address. Come on. They go through all of the different aliases, the agreement to borrow $3.8 million, or the fake agreement, the fake loan documents, fake documents submitted to the court. The accused proposed to Lisa Marie Presley's surviving daughter's attorneys. This is not talking to Lisa Marie Presley's daughter. This is talking to her lawyers. Proposed to the lawyers without disclosing that the creditor's claim was false and fraudulent, that she would be agreeable to settle the claim for $2.85 million, which represented 75% of the amount that she falsely claimed that Lisa Marie Presley had borrowed. Not just emailing the target, talking to the lawyers. How do you think that this is a good idea? You don't think suspicious minds, lawyers, the lawyers are the suspicious minds. The lawyers are like, nope. Oh my God, the lawyers aren't going to trust your lying eyes, lady. This is not going to go well. Submitted fake loan documents to the Shelby County Registrar's Office in Memphis and record fraudulently the fake deed of trust. Oh, there was a fake deed of trust. See, this is why we go to the documents, not the article. The fake deeds of trust can be an absolute bitch to unwind. Probably less of a problem for Graceland because I don't think they're going to be trying to transfer title that much, but it can create such a problem. But to try to fraudulently record a fake deed of trust, to fraudulently auction off Graceland, the published notice of foreclosure was in the commercial appeal. Interesting that they thought nobody would pick up on that. And then it goes on from there. Mostly what we saw in the other documents, going through who Elvis Presley is, what Graceland is. I need to start naming my properties more. I've always named my car. Do you guys name your houses? I feel like I should. In 1982, Graceland opened to the public. Since then, Graceland has become one of the most visited homes in America. In 1991, Graceland was placed on the National Register of Historic Places. In and around 2006, it was designated by the Secretary of the United States Department of the Interior as a National Historic Landmark. Come on. Come on. The amount of paperwork you have to go through to try to deal with something that is a National Historic Landmark and something that's on the National Register of Historic Places, and you think that this is what you're going to do. It's wild. Kay Ashley says, is Emily saying that Fidley, the accused, should not be cruel? I'm all shook up. Well played. Chat, the Elvis lyrics have been 10 out of 10. 10 out of 10 out of 10. 10 out of 10. Rare in the History said, our place is called Crackleberry Creek because I needed a farm name to register my poultry flock. I love that. I absolutely love that. A friend of mine, hello friend of mine, just got a white Jeep, beep beep. It is named Cher, like Cher from, oh my God, my brain just stopped. How is my brain? This is why we don't stream while sick. It's not because we don't sound good. It's because my brain has absolutely stopped. Cher from Clueless. My brain was just like, whoop. Sorry, Candace. But congratulations on Cher. Anyway, Cher from Clueless, not Cher the singer, but yes, also Cher the singer. But anyway, so Clueless. The by Just With Love said, is the accused the devil in disguise? You're the devil in disguise. Yes, exactly. Exactly. So with all of it, there we go. We've got the National Register of Historic Places and National Historic Landmark trying to be stolen and auctioned off. I will say that I did prosecute a crime out of Santa Monica where somebody had tried to steal a house and it fucked up title. They moved into the house. They would not leave the house. It was an absolute mess. And it really took quite a while to undo all the issues with title, which the homeowners were in the middle of selling that home, and it cost them a ton of money, just a ton of money to unwind all of the title issues that fraud can cause. What's really frustrating is that, you know, when you are dealing with the death of a family member at all, what you shouldn't have to be on guard about while you are grieving is unscrupulous parties trying to defraud you. But the higher profile somebody is, the more you're going to have to, I suppose, deal with unscrupulous characters. We're going to talk about that more in tomorrow's podcast. Where did my lip gloss go? Talk about that more in tomorrow's podcast, talking about Matthew Perry. Forget it. The lips are just going to be pale at the moment. There we go. There we go. It's just so frustrating. So, want to talk about people stealing shit? Let's talk about people that you can't trust stealing shit. Yeah, that's my segue into Murdaugh today. People you think you can trust stealing shit. Let's talk about Alec Murdaugh. That's actually where we're going. But in sum, if you're going to try to steal a house, you know, not legal advice, but one that's on the National Register of Historic Places and is a designated national landmark is maybe not the best call. Also, thankfully, there's lawyers here to kind of intercede. So when you can pass things along to the lawyers and let the lawyers suss it out, you're in a better place. You know who's not in a better place? Emily, 7 segues. You know who's not in a better place? Alec Murdaugh, sitting in a sitting in custody. Yes, we are going to be talking about Alec Murdaugh. Yes, there are multiple things going on with Alec Murdaugh, including the Supreme Court agreeing to take his case. He is appealing his sentence in the federal case, even though it's per a plea deal. And part of the plea deal said, by the way, you can't appeal. Like, he waived his right to appeal, but he's trying it anyway. If we have time, we'll get to that. The courthouse Becky of it all. Have you guys heard that the egg juror is writing a book? Like, none of this is going to get better. The book isn't going to help. Like, none of this is going to help. None of this is going to make anything better. But let me pull up the Murdaugh documents real quick, and we'll start with the Supreme Court, and then we'll work our way backwards to him trying to appeal, even though, and we'll just pull up the document from his plea deal, even though he can't. And then we'll get to the tea on the egg lady juror. I think we do that last. Do you guys agree? I think we do that last. So let me pull up the Murdaugh document, and then we'll do a quick road so far. I don't think I can do both at once, because I don't think my brain has the capacity to multitask in the way that I normally do. Did I link all these things together somewhere? Yes, I did. Can I find that? No, because I did it last night, and there is a high percentage that I just didn't save it because I'm sick. This is why, like, judges have unlimited sick leave, because they're like, I can't work when I'm sick, because your brain is just like, what is even happening right now? So we're going to talk about the appeal first. Let me grab the Supreme Court. We've got a couple documents that I haven't gone over yet that I want to go over with you in this appeal. So we're going to do all of that together. Let's do a quick road so far. Alec Murdaugh, like, the trial at this point is so far away that we're like, when did Alec Murdaugh go to trial? And didn't we cover that? The 3-week trial that ended up being an almost 7-week trial because we took a whole detour into all the fraud cases. He was still supposed to go to trial on all those fraud cases, ended up pleading on almost everything. So Alec Murdaugh has been sentenced in state court for the conviction on the death of his wife and son, Paul. He has been sentenced on the federal theft crimes. He has pled and was sentenced on the state level theft crimes. There are still, or there were still, some outstanding tax cases. I don't know if those have resolved yet or not, but it was like 40 years federally and 22 years state, and then life plus life on the murders. Then after the murder conviction, all kinds of information started coming out about Courthouse Becky, the clerk of court who oversaw the Murdaugh trial, and whether or not she was interacting or interfering with the jurors. This resulted in tons of motions, lots of allegations, and a hearing from all of the jurors. So the court brought in every single juror on the case and inquired about whether or not Courthouse Becky had talked to them. And there was one juror who said that they were influenced by the things that Courthouse Becky said. There were several jurors that said, yeah, she talked to me. It seemed weird, but whatever. We got a data dump of all of Courthouse Becky's emails where she was talking about how unfair it is that Putin and Jim are going after her, and talking about her book, because of course there was a freaking book. I have it somewhere. Hold on. Where'd it go? I have a stack of ill-advised books. Hold on. Not the Federal Rules of Civil Procedure. These are not the ill-advised books. Wait, where's my KFD book? My KFD book is missing. But sometimes what you write in the pages is going to come back and bite you in the butt. This book you can't get anymore. So it has been taken out of publication due to plagiarism. So we got this for research purposes before the plagiarism. I've got KFD's book around here somewhere because he's getting ready to go to trial. Look, if you write a book and then it lands you into more hot water, I will probably have that book here somewhere. So Courthouse Becky writes a book, and she is talking about we throughout this book. She is talking about herself with the jurors in a we, like we the jury. It's wild. But also there's parts that are plagiarized, which is also wild. Her co-author was not thrilled and then has written another book. So Courthouse Becky has gotten herself into a whole bunch of hot water, and she testified in that hearing as well. After Courthouse Becky's testimony, the court ended up ruling, and this was the court under Justice Toll, a former Chief Justice of the South Carolina Supreme Court. Justice Toll found that under the standard in South Carolina, that Alec Murdaugh did not prove that he was prejudiced by the things that the clerk was doing. The federal standard is different. In that content, I talked a lot about the differences. We're going to go through the Supreme Court filing, and we're going to go through the filing that the defense submitted that prompted the Supreme Court to take this case up. So we're going to go through those two things and look at those differences in standards. There is a split in standards between how South Carolina is evaluating these things, how the federal courts in other states are evaluating these things. Those are the type of things that the federal Supreme Court takes up. And these are the types of things that state Supreme Courts often will take up because there is a difference here. And with the difference, we will see if the state Supreme Court shifts the standard, Alec Murdaugh may very well get a new trial because the federal standard only has to show that somebody talked to the jurors, somebody external talked to the jurors. And if that somebody works within the court system, it's presumed to prejudice the defendant. That presumption works on Alec Murdaugh's behalf. In South Carolina, he has to prove that he was harmed. So if the state Supreme Court changes the standard that they apply in South Carolina, which could be a reason they're taking this up, then we might see a new trial granted. We are a long way away from that yet, but this is going to go faster because Alec Murdaugh is going directly to the Supreme Court, do not pass, go. So with the do not pass, go, we're just at the Supreme Court instead of going through the appeals court. So let's pull up what the state Supreme Court did, and then we'll go to the filing that the defense made that prompted this. So we'll talk about what it means if there is a new trial after we get through these filings. Chat, don't worry, we'll get to questions. So let's do this way and make this bigger. This is a pretty quick little notice, but it's important. Fast, but powerful. That didn't sound right. We're going to let it go, though. We're just going to let that go. The Supreme Court of South Carolina, the state versus Richard Alexander Murdaugh, appellant Murdaugh, asks this court to certify the appeal in appellate case number listed for review by this court pursuant to Rule 204B, South Carolina ACR. The motion is granted. That's it. Because the transcript has been delivered, appellant shall have 30 days from the date of this order to serve and file its initial brief as required. This was August 13th. So by September-ish, whatever 30 days is, we've got 31 days in August. So September 11th, 12th, we should see their filing. But I'm going to pull up the filing that I think prompted this and go through it. So they are going to take it up. Normally, this would go through the Court of Appeals, and then it would go all the way through the Court of Appeals. And then depending what the Court of Appeals does, then you can appeal it to the Supreme Court. And then the Supreme Court can say, you know what? You're right. We should use a different standard. Or you know what? You're wrong. We're going to stick with the standard that we use. Instead of it going through the full appellate court and then going to the Supreme Court's like, we're just going to take that now. And I'm not surprised that they're doing that because there is a split in authority and because Justice Toll really laid that out in her ruling, saying, under the law of the land today, this is what it is, and laid out a really thorough ruling. But if that law of the land changes, then the ruling changes. We are not going through all 47 pages of this, but we are going to go through some of it. This is the initial appellate opening brief, and we are going to look at how they define the split in authority that's going to be so important in this case. Yeah. You're all like, yes, that's what we're here for. Yes, you don't need to ask. This is exactly what we're here for. I should sweep. So they're going to have to file a new one. I imagine it will be similar. So we'll see. We'll see what they decide to do. This should be, yeah, as I said, this should be similar to what we're going to get. Let's see, initial brief. This is their table of contents. We're going to jump around a little bit. Their argument is, quote, there is an irrebuttable presumption of prejudice when a state official secretly advocates a guilty verdict in the jury room during a criminal trial. There are some arguments there to be made that Courthouse Becky wasn't advocating, but one of the jurors said that they felt that this had shifted. There's no argument that Courthouse Becky's not a state official. The U.S. Supreme Court holds that in a case, that in a criminal case, jury tampering is presumptively prejudicial. This, again, is different than the standard at the time in South Carolina. The presumption of prejudice is irrebuttable when a state official tampers with a jury during a criminal trial about the merits of the case. The trial court's finding that Ms. Hill's comments to jurors that were not overt as to opinion is unsupported and contrary to the evidence on the record. So they're arguing what Becky said, and was it really impactful statements? Even if the presumption of prejudice was rebuttable, the state did not rebut or even attempt to rebut the presumption of prejudice in this case. There was prejudice proven at the evidentiary hearing. So they're going strongest arguments to weakest arguments, and they're trying to say, look, change the standard. They want the courts in South Carolina to adapt the standard that is the federal standard. Those are all the case sites. We're going to go through their summary real quick. Statement of issue on appeal, and I think this is why the Supreme Court took this up. Is prejudice to the defendant's right to a fair trial presumed when a state official secretly advocates a guilty verdict in the jury room during a criminal trial? Is prejudice to a defendant's right to fair trial proven when it is found that a state official tampered with the jury and a juror testified that the jury tampering influenced her verdict? And 3, is secret advocacy for a guilty verdict in the jury room by a state official during a criminal trial a structural error in the trial? So these first two would cause the standard to change if the Supreme Court in South Carolina agrees. The third one is arguing to the standard as it is today. So it's that arguendo position. Like, if the standard changes, then this. If it doesn't change, then this. Let's see. This is the statement of the case from the defense position, but I think there is room to argue that Courthouse Becky's statements didn't influence the jurors. But when you have one juror saying they're influenced, I don't think courts are going to be friendly to that. It raises too many questions. So I think Courthouse Becky has caused an inordinate amount of problems here, and I'm going to be surprised if this doesn't at least end up in quite a significant amount of conversation, right? Statement of the case from the defense. Richard Alec Murdaugh is a disgraced former attorney and drug addict. Well, they're coming in hot. These are his attorneys. His attorneys. His attorneys are like, this framing is helpful. Once a prominent member of the bar, who are we talking about? Are we talking about Murdaugh or are we talking about Girardi? Which once prominent member of the bar with deep political connections are we talking about? Once a prominent member of the bar, Murdaugh stole millions from his law firm, his clients, and others who trusted him. His law firm confronted him about his thievery on September 3rd, 2021. He resigned from the firm and, after a failed suicide attempt assisted by his drug dealer, entered drug rehabilitation. I don't know if that accurately depicts what happened there. I really do think that was a insurance scheme, and that's what he was charged with. And didn't he plea to the insurance fraud there? Like, I think after he's pled to it being insurance fraud, you can't really argue that it wasn't. Like, I don't know. I think it's a little disingenuous to try to argue that that was an attempt when it seemed that it was a scheme against insurance. So that's me being picky, but either way. Chad, I agree with you. Tony's like, misstates facts and evidence. I agree that it misstates the evidence because he did plea to that. Let's see. 3 months earlier, on June 7th, Murdaugh's wife, Maggie Murdaugh, and younger son, Paul Murdaugh, were brutally murdered at the dog kennels of their rural family property in Colton County. Murdaugh was indicted for the murders for related firearms offenses on July 14th, 2022. The jury trial commenced January 23rd, 2023. Hasn't been that long. The Honorable Clifton Newman presided. I miss Judge Newman. I really do. Let's see what their footnote says. Their footnote says, in initial court proceedings to the state is objected to referring to former Colton County Clerk of Court Rebecca Hills, a state official. Okay, state? Are we arguing that Becky's not a state official? She's literally an elected official for the county. Are we arguing? Really? Come on now. No. It said Mr. Murdaugh does not mean that her improper motives or conduct should be imputed to the prosecution or law enforcement in this case, but it is inarguable that Ms. Hill acted in this case as an official of the state of South Carolina. I agree with the defense on that. She is a state official. It doesn't mean she works for the prosecution, though she was emailing them quite a bit. She might have thought she did. They didn't think she did. But it's inarguable that Ms. Hill acted in this case as an official for the state of South Carolina. I agree with them on that. She held an elected office created by Section 24, Article 5 of the South Carolina Constitution. Her duties included summoning and paneling and managing the jury, and she was able to interact with the jurors in Mr. Murdaugh's murder trial only by virtue of her office, and was like using her office. She's actually being prosecuted, or not being prosecuted. She has ethical charges against her. Me thinking at some point the prosecution will come. Ethical charges against her for improperly using her office to like influence peddle. She was using her email to have like, oh, just come to the side door and I'll get you into the trial and I'll do this and I'll do that and I'll take pictures about this. And she used her office to peddle influence and raise her own profile and to be in the middle of all that was going on, to be in the cheesemate, to be part of the trial, to feel the lights of what, infamy? I mean, everybody's talking about you, Becca Boo. I don't think it's the way she wanted everyone to be talking about her, but everyone is absolutely talking about you, Becca Boo. For those of you asking, Lori, I see you asking, and a couple others asked about any new info on her son's prosecution. I have not been able to find any updates on that at all, which doesn't surprise me. It's slow. So let's see. This trial. Murdaugh was indicted for the murders. Clifton Newman, we miss.
Bring the jury.
We miss you, Judge Newman. Presided. The state claimed Mr. Murdaugh was confronted at his law firm earlier that day about missing attorney's fees. Well, it's not that they claimed. I think they proved that clearly. I don't think there's any question that the state proved that he was confronted that day. Of all the people that testified in the Murdaugh case, Jeannie Seconder stands out to me. Jeannie knew her shit and was like, Tom Petty up in there. She's like, I won't back down. She's like, I'll testify at federal cases. I'll testify against my brother-in-law. I'll testify against this dude I went to high school with. She's like, what you did is put your clients and my job on the line, and it is not okay. It is not okay at all. She absolutely confronted him. That's not just the state. The state proved that. The state claimed. The state claimed Mr. Murdaugh was confronted at his law firm earlier that day about missing attorney's fees and that he came home and killed his wife and son to distract a bookkeeper investigating those fees and to reduce his financial exposure in a negligent entrustment suit filed over 2 years earlier regarding a boat which Paul allegedly operated while intoxicated, resulting in the horrible death of a young woman, Mallory Beach. They didn't put it in there. I'm going to. Mr. Murdaugh also admitted all allegations of theft, but vehemently denies murdering his family. After 6 weeks of trial, the 3-week trial was like a 3-hour tour. Very, very, very much a 3-hour tour. After 6 weeks of trial, the case was submitted to a jury at about 3:45 p.m. on March 2nd. The verdict was returned early that evening. I don't even think I had finished streaming by the time the verdict came in. I think we were still answering questions. I was shooketh that jury came in so fast. Shooketh. The verdict was returned early that evening. Jurors' television interviews indicate the actual deliberations took less than an hour. Mr. Murdaugh timely appealed the verdict. The appeal is separate from this appeal. So there's an appeal to the verdict. This appeal is appealing the ruling on the motion for new trial. So there's two. There's an appeal. There's an appeal regarding the trial, and then there's an appeal regarding the new trial. We are in the appeal dealing with the motion for new trial. I know, it's a lot of appeals. On August 1st, 2023, the then Colton County Clerk of Court, Becca Boo Hill, published a book, Behind the Doors of Justice. If you want to know if your books will be used against you, here it is again. I illustrate the book as being a terrible idea with derision, not as being a good idea, but I also like having a physical prop. So there we go. Behind the Doors of Justice after Mr. Murdaugh's trial. She had been planning to write a book about the trial even before it began, which we learned from all of her emails. She repeatedly said that a guilty verdict would sell more books. That I don't remember at all. I'll have to go look. I don't remember that part at all. Chat, if you remember, let me know. I don't remember she said that a guilty verdict would sell more books. Honestly, I think a hung jury probably would have, but you let me know what you think. I don't remember that at all. And that she needed to sell books because she needed a lake house. That I remember. I absolutely remember her. It sounded like she was cracking with her coworker who was kind of put off by the whole thing, being like, well, we need to get that lake house. So, let's see. The book caused some jurors to come forward and describe Ms. Hill's efforts to obtain her desired guilty verdict through jury tampering at trial. Jurors stated that after the state rested and the defense began its case, Ms. Hill entered the jury rooms often, telling jurors not to let the defense throw you all off or distract you or mislead you, and telling them not to be fooled by Mr. Murdaugh's testimony in his own defense. And this comes from the juror's testimony. Under a different standard, that might be enough. On September 5th, 2023, Mr. Murdaugh filed a motion to suspend his appeal for leave to file a motion for new trial based on the jury tampering evidence. The court granted the motion. Murdaugh filed his motion for new trial on October 27th. On November 1st, he petitioned the Supreme Court for a writ of prohibition to prohibit Judge Newman from adjudicating the new trial motion based on public statements Judge Newman made after the jury rendered guilty verdicts. Excuse me. On November 15th, the Supreme Court denied the petition as moot because Newman recused himself from hearing the new trial motion. On December 18th, the Chief Justice appointed retired Chief Justice Jean Toll to serve as the circuit judge hearing the motion for new trial. It's a really good summary. Look, it's argumentative. I disagree with their positioning on some of the things, but of course I do. This is their motion. It is supposed to be argumentative. It is advocacy. It's in the light most favorable to them, but it's a really good recitation. So it's clear, which I appreciate. The trial court ordered an evidentiary hearing, and the parties submitted extensive briefing in advance of the hearing. I covered all of that. We have a playlist. I wonder if we need to break the playlist for Murdaugh into like a playlist for the trial and then a playlist for all the after trial fuckery. Like, I feel like we might just need two. Like, keep the trials together with just like the court. Emily, are you planning things out while we're in live stream? Yeah, I can't rein in the ADHD when I'm not feeling well. Apologies. But I feel like if we do a playlist for the trials, you can watch gavel to gavel, and then playlist for all of the motions like pre-trial and post-trial. I think that would help. You guys are like separated lists would help. Yeah, perfect. All right. We'll do that. I'll do that later. Miguelina, you don't have to do that. I'm not asking you to do it right now. Miguelina's like, girl, we already did that. We already did that. Hunk Banana Nose said you should break down into a facts playlist and a fuckery playlist. Right? We might need to do that. Like the pre-trial motions, the trial, and then the post-trial motions. RK quoting The Offspring in the chat is 10 out of 10. She's like, no, we've already done it. Okay, good. I'll make sure they're more obvious to me because I forgot. Look at us. We did things that would be logical. And then my brain's like, did we do the thing that's logical to me? They say that the trial court held a pre-hearing procedure on January 16th to determine who had the burden of proof in this matter and what must be shown to meet that burden of proof and what must be shown to contest what has been shown and proved. At this hearing, the trial court ruled that Murdaugh bears the burden to prove actual prejudice in the verdict rendered. This is the most important part of all of this. This part. This is what they're arguing. This is the part that matters, hands down. Does Murdaugh bear the burden to prove actual prejudice from what Courthouse Becky did? The federal standard says no. The South Carolina standard says yes. And that is what the fight's over. That is what the fight is over. The court said it further ruled Murdaugh would not be permitted to call any witnesses, including eyewitnesses, to Miss Hill's jury tampering or to examine any jurors called by the court. Instead, the trial court would call itself and examine each juror. The only other witness would be Miss Hill, and any cross-examination of her would be strictly limited. On January 24th, the trial court communicated its proposed questions to jurors to the parties. Murdaugh's counsel objected to some of the questions. I think this part of the process was appropriate. I understand the argument on the standard. I can't tell you what the right answer is because the Supreme Court in South Carolina can change the answer. If they say it's time to reevaluate the standard, then they get to change it. So I think that the defense has accurately recited the problem. There are these two different standards in this limited and narrow circumstance. Remember, this circumstance is only dealing with state officials. And that would be like a bailiff, a clerk of court, a judge. This isn't dealing with a rando third party on Reddit or whatever. No randos. This is dealing with truly the cases that have come up is dealing with bailiffs. But the clerk would fall into that. I mean, I don't know. Or a court interpreter. Do I ever think that would happen? No. But could it? That's what they're talking about. People employed by the court system, by the state, even a county state. So it's a very, very much more narrow circumstance than other cases we've seen with jurors because it deals specifically with juries being tampered with by agents of the government. That's it. Narrow question. South Carolina says the defense has to prove prejudice. The Supreme Court for the U.S. says that prejudice is presumed based on their position. Let's continue. So I think they've identified the issue clearly. And I think the Supreme Court is taking this up because they want to resolve the conflict. It might be that the Supreme Court wants to say, no, we're standing by our standard. It might be the Supreme Court is saying, no, we're changing our standard. So is there a right answer here? No. The court gets to decide which standard. It could be either. We're going to have to wait and see. All right. On January 24th, the court communicated the proposed questions. Again, I don't think the court should have allowed just open questioning. In all jurisdictions, like we've seen in the Karen Reed case, you can't just inquire as to every deliberative process. They have to really narrow down what is being asked about, and that's why the court did it this way. I agree with the court on this. Murdaugh's counsel objected to the questions and the rulings made at the hearing by letter dated January 25th. We went over all of that on the channel. The trial court considered its prior rulings and allowed Murdaugh to call an alternate juror and Barnwell clerk of court, Rhonda McLovin. Not McLovin, Emily. Not McLovin. Rhonda, by the way, was not having any fuckery. Rhonda was great. The defense is like, help me, Rhonda. And Rhonda's like, fuckery. So much fuckery. Rhonda was great. Rhonda is what most clerk of courts I had interacted with were. Following the rules, absolutely on the straight and narrow. Look, I tell you when to come in. I tell you when to leave. If you have any questions about that scheduling, you can ask me. Anything else, I can't help you. Like, I got you for scheduling. I got you for food. You need water, Band-Aids, Advil, whatever. We got you. But we can't talk to you about anything else. Freaking loved Rhonda. Rhonda was not having any of the bullshit. And Rhonda had been a clerk of court forever. Remember, this was Becky Hill's first 4 years as clerk of court. Her very first go at being like the elected clerk of court. The evidentiary hearing was held January 29th, 2024. That was this year. Doesn't it feel like it was 100 million years ago? We've been through so much since this hearing. This hearing was everything. So it's wild. The evidentiary hearing was held on January 29th. A single juror testified one business day earlier on January 26th to accommodate a scheduling conflict, and we covered all of that. The jurors testified, jurors CFLEOYWQK testified that they did not hear Ms. Hill comment on the merits of the case before the verdict. Juror P testified that he heard Ms. Hill tell jurors regarding Mr. Murdaugh's decision to testify in his own defense, watch his body language. Juror P testified the comment did not affect his verdict. Juror X testified that she heard Ms. Hill's comment regarding Mr. Murdaugh's decision to testify, that it was rare for a defendant to testify in a criminal case, and that this is an epic day. Juror X testified the comments did not affect her verdict. If I was Juror X and what I had heard was like, this is an epic day, I'd be like, ew. He's on trial for murdering his son. Like, why are you talking to me? Juror Z testified that she heard Ms. Hill regarding Mr. Murdaugh's decision to testify in his own defense to watch Mr. Murdaugh's actions, watch him closely. Juror Z testified that the comments did affect her verdict. Question, all right, was your verdict influenced in any way by the communications of the clerk of court in this case? Answer, yes, ma'am. And that's when I was like, look, man, under the Supreme Court standard, that's enough. Under the other standard, that might be enough. Sorry, Dr. B is texting me. Let me check what Dr. B is texting me about. Oh, Dr. B is like, I'm heading to the gym. Enjoy, Dr. B. Dr. B is off on Tuesdays. All right. And which means he has to do all of the things today because I'm not doing any of the things. I'm doing this and then I'm going back to bed. So was your verdict influenced? Yes, ma'am. How was it influenced? To me, it felt like she made it seem like he was already guilty. Question, all right. And I understand that that's the tenor of the remarks she made. Did that affect your finding of guilt in this case? Yes, ma'am. I think that's why the Supreme Court's interested in taking this up. The trial court then examined Juror Z regarding her affidavit attached to Murdaugh's motion for new trial. She affirmed each paragraph therein, including averments during the trial that Ms. Hill told the jury not to be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified, and that Ms. Hill instructed the jury to watch him closely immediately before he testified, including look at his actions, look at his movements, which I understood to mean he was guilty. The trial court then asked, Juror Z, I asked you previously, was your verdict on March 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answered that question, yes. In light of what you said in your affidavit, which is, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. is that answer that I just read a more accurate statement of how you felt? So which is it? Did you vote guilty after deliberations, or did you vote guilty because of what Ms. Hill said? And then the answer, or the question was, is that answer I just read a more accurate statement? Harpootlian said, objection to the form, Your Honor. Harpootlian objected to the court's question, and the court was like, overruled. Like, the fuck? Overruled. Overruled. And then the answer was, yes, ma'am. And then the question was, all right, so you stand by the affidavit? Yes, ma'am. Very good. After Juror Z left the courtroom, hold on, I got distracted. Apologies. After Juror Z left the courtroom, Mr. Murdaugh's counsel objected. Mr. Harpootlian said, Your Honor, we object to the questioning because this juror gave two statements under oath, one in an affidavit and one here to you today. The one here to you today was Becky Hill influenced her verdict. The court said yes. Harpootlian said, then the one she gave in the affidavit 6 months ago was based on jurors. It could be both. Your Honor picked out one of the affidavit from 6 months ago and said is that the more accurate statement? That's what the court asked. That presupposes the suggestion to her what she should say. So they're saying, Your Honor, you led her to the conclusion you wanted, or at least that's what they're implying strongly. And we believe that this juror's testimony, and Your Honor, I'm afraid what you're going to say is, well, she said the affidavit was more accurate than what she testified under oath here today, and therefore I'm not going to consider her testimony. And I think that's where we're headed here. You continue to read the situation accurately, Poot. That's exactly where you're headed there. So Poot goes on to say, I'd ask you to bring her back in, explain to her there's nothing wrong with it both being true. And the court's like, I am disinclined to acquiesce to your request. The court said, I decline to do that and overruled the objection. I think the court's looking at this through the lens of what you said 6 months ago before the media hoopla is probably more accurate than what you're saying today. Maybe not, but we will see. Later during the hearing, Juror Z, through her own counsel, provided an affidavit. This was after lunch. It seemed to me that over the lunch break, there was conversation. Later after the hearing, Juror Z, through her own counsel, provided an affidavit averring, I had forgotten about this. I would like to clarify my testimony today. As I testified, I felt influenced to find Mr. Murdaugh guilty by reason of Ms. Hill's remarks before I entered the jury room. This started to feel a little much to me. Once deliberations began, as I stated in paragraph 10 of my earlier affidavit, I felt further additional pressure to reach a guilty verdict. I remember that. It was like, what I said here is true, but my affidavit is true. But what I said here is true. It was like, but Becky did it. And this, I think the court might have had questions about whether or not these statements were coached. So I think there were some questions that the court had with regard to all of this. And that's the additional affidavit. I forgot about that. Although the trial court introduced Juror Z's pre-hearing affidavit into evidence on its own motion, it refused to allow Juror Z's affidavit of that day into evidence or to allow any further testimony from Juror Z. Ms. Hill testified after the jurors. Wasn't that wild? The clout circus of it all. She denied engaging in jury tampering. She also denied that she stated she wanted a guilty verdict to promote her books. She admitted she plagiarized portions of her book and that her profits from the sale in the 6 months before it was withdrawn from publication because of her plagiarism was approximately $100,000. It's not nothing. Examination by the trial court revealed that Ms. Hill's denial during direct examination of questioning a juror during the murder trial was not truthful and that she did not want a guilty verdict. The clerk of court from Barnwell, Rhonda, testified to rebut Ms. Hill's denial that she wanted a guilty verdict. Oh, good, we're getting to it, because I had forgotten this. So I'm glad they brought it back up, because I had forgotten. Oh, trying to get myself back into the January. We've done so many trials this year. We've done so many trials this year. Oh, so many trials. Rhonda said she was assisting in the courtroom during the trial of Murdaugh. Said, question, and did she discuss, this is Becky Hill, and did she discuss with you, what if any, oh God. To everyone on the defense team that thought it would be hilarious to make us all read what if any, it's not funny. I don't, stop it. Stop trying to make us what if any. No, not the what if any. Ugh. And did she discuss with you, what if anything did she discuss with you about how she felt the verdict should turn out to be in the Murdaugh trial vis-a-vis in reference to the book? What would help the book? A guilty verdict. I had completely forgotten about this. I'm glad it's in here. Except for the what if any part, but whatever. Tell the judge, Poot, and me, what exactly she said that you remember this prior to the trial. This is prior to the trial. That's compound. Okay, well, first of all, she said we might want to write a book because she needed a lake house and I needed to retire. And from then, further conversation was that a guilty verdict would sell more books, and we left it at that. This was before even in December. I still think that the I need a lake house and you need to retire is colloquy between colleagues. I don't know if that's super literal. I think that's very jokey. Like if you joke with your colleagues, like, yeah, and I need a yacht. But then again, I don't think Becky Hill was writing the book to not make money. I think she absolutely was trying to make money off the book. Of course you're trying to make money off a book. I don't know if money was the number one for Becky Hill. You guys let me know in the chat. Was money number one, or was some level of 15 minutes of fame? Was the siren song of getting on a plane and going to New York to be on the, Good Morning America or the Today Show or whatever? Did she desire that more? Like, the money is part of it, but the fame, the clout goblininess of it all, is that really the standing and your face everywhere? Is that really what she wanted more? Because it seemed to me that that's what she wanted more, the attention. And then the money was like a part of the attention. That's at least what I took away from it. So let's see. Question. And when did she ever say anything to you during the weeks you spent there? So during the trial? Answer. Several times. It could be said it was, amongst friends in her office, or we might be having dinner, that kind of stuff, but that's about it. Question, that she needed a guilty verdict to sell more books? Answer, that would be the best way to sell books. Yes, sir. So she had that conversation. That's right. She had that conversation with the other clerk of court. The best way to sell books. Now, during this process, did she ever express, so this is another question. Now, during this process, did she ever express to you an opinion on whether or not, in fact, was Mr. Murdaugh guilty of the murders of his son and his wife? Yes, sir. Tell me what she said and if you remember when. I don't exactly remember when. I know it was over half of the trial had already happened, but the evidence was coming forth and it looked like he might be guilty. She made a comment that a guilty verdict would be better for sale of the books. I had, completely forgotten that this was all in conversation with the other clerk of court, not the emails and what have you. This was from testimony. Oh, Becca Boo. This is why she's like XOing Nancy Grace in her emails. She's just like, I'm here if you need me. She also testified that Ms. Hill made comments to her like, don't be fooled by the evidence presented by Mr. Murdaugh's attorneys, identical statements reported by some of the jurors. And she testified that Ms. Hill insisted on allowing a book writer who wrote the foreword to Ms. Hill's book to sit in the well of the court during trial, where she could see sealed exhibits under the subterfuge of being a Sunday school teacher. What? I remember that. That was so fucking weird. You can't sit in the well. I'll tell you what, if I'm prosecuting a case and there is someone sitting behind counsel table that I don't know in the middle of trial with a jury present, I'm like, get out. The final witness was alternate juror 741. She testified that Miss Hill told jurors the defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse or convince you or throw you off. At the conclusion of the hearing, the trial court ruled from the bench. Did the clerk of court make comments to any juror which expressed her opinion what the verdict would be? Ms. Hill denies doing so, and so the question becomes, was her denial credible? I found the clerk of court is not completely credible as a witness. Ms. Hill was attracted to the siren call of celebrity. Chat, you agreed. Chat, you agreed. All of you were just like, yep. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda, that others her desire for a guilty verdict because it would sell books. So the court made that as a finding of fact. The court found as a fact that Hill stated she wanted a guilty verdict. She made comments about Mr. Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more of the jurors. The clerk of court allowed public attention of the moment to overcome her duty. 10 out of 10 agree. 10 out of 10 agree. 10. And I do think that because Justice Toll is a former Chief Justice of the South Carolina Supreme Court, that her saying siren call of celebrity is probably elevated to me saying clout goblin. So maybe I will. No, I won't. Yeah, I will. I'll try to keep both in the verbal repertoire. So we have both the clout goblininess and the siren call of celebrity. It's just so much more elegant. Justice Toll would never say clout goblin. I would. But also, I live with a junior high school student, so the fact that I don't just absolutely accidentally say skibbity sometimes is hilarious. And as my teen has gone back to school, I was taking him to school, and some of the freshmen were wandering around. And now that my teen is like a junior, the freshmen look like itty bitty. I was just like, oh, they look like they're little, they're freshmen. And he's like, they all sound like junior high school students. I'm like, right. He's like, right. They brought the Skibbity Riz Ohio bullshit. And he's like, it is just. I'm like, mm-hmm. So my teen is like, ugh, freshman. It's so funny because it feels to me like he was there like 6 seconds ago, like in the eyes of parents. Anyway, it's hilarious. So the court was elegant and well-spoken. Very much more so than me and my brash common language. Don't worry, the comment section often reminds me, not y'all. It is people who don't have the chutzpah to be in the live chat that pop in and are like, your mouth. And I'm like, I know, right? The trial court nevertheless denied the motion for new trial, reasoning that there is no presumption of prejudice from tampering with jurors during trial about the matter pending before the jury, and Mr. Murdaugh failed to prove that Ms. Hill's comments changed the jury's verdict. The trial court discounted the testimony of Juror Z, who said Ms. Hill's comments did affect her verdict because she was ambivalent in her testimony. In a state-drafted written order entered 66 days after the ruling from the bench, the trial court further ruled in passing that, quote, this court finds that any possible presumption of prejudice was overcome without any reference to any evidence presented at the evidentiary hearing. Mr. Murdaugh timely appealed the order on April 11th, 2024. On March 25th, 2024, Hill resigned from office. In May 2024, it was reported that the State Ethics Commission had referred ethics complaints against her for criminal prosecution. We haven't seen those yet. We might see those soon. I don't have any inside information on that. We might see those in the future, I should say. That's probably better. Standard of review. So this is about how to grant the new trial. the court, I think, is going to take up the issue of whether the standard is correct. I think that's the reason the Supreme Court said do not pass go. Argument. The trial court found Ms. Hill tampered with the jury during Mr. Murdaugh's murder trial. The only evidence the state presented contradicting sworn testimony describing the tampering was Ms. Hill's own denial, which the trial court found not credible. Agreed. The trial court found she was motivated by a desire to sell books. Okay, look. To the defense team, I think Mr. Barber probably wrote a lot of this. I quite like his writing. Mr. Barber, I'm going to talk directly to you because Jim and Dick don't get it. Phil, first of all, you have the best sunglasses on the defense team, which is why we are appealing directly to you. The argument that she wanted to sell books is not the strongest argument. This woman wanted attention. The court found that she was motivated by attention. The court found she was motivated by the siren call of celebrity. Selling books is a side effect because selling books equal attention. Like, look, people bought my shit. It is not just about money. This is 100% about the attention. And if you focus in on the fact that she wanted to be in the middle of all of the chisme, then you will see the bigger picture here, which is she wanted to endear not just the jury, but her staff, because we saw all the ethics complaints about her throwing every single party under the sun with the taxpayers' money. She wanted to be in the middle of it. She wanted everyone to love her. She wanted to be the one opening the back door and letting people... It's in the emails. And I mean the back door to the courthouse. Opening the back door to the courthouse and letting people in without going to security. She was brokering an influence to feel important. Her daughter was out with a hat playing guitar for the media pool. She was giving her personal cell phone number to reporters and to Nancy Grace, signing her emails from her business email, her state email, XOXO Beckaboo. She wanted to be in the middle of this. She wanted the attention. She wanted the fame. She wanted to be known as everyone's bestie, Becky Boo. She wanted to be in the middle. And so she tried to center herself in this trial instead of just doing her job. And when clerks of court or court clerks do their job well, they are often thanked by the attorneys, and no one else normally sees their work. She wanted to be seen. It is like nurses. Nurses who do great work don't always get the recognition that they deserve other than from a handful of their peers, hopefully the doctors and the patients who they alter, but they're not the ones on the news when something goes right? It's the doctor. It's the same with the clerk of court. You are not the main character. So when things go right, you get thanked by those immediately in the courtroom, and that's where it stops. It's not a high-profile job. It's a job you do because you want to be a public servant and you want the wheels of justice to not grease your pockets or your ego. Well, Beckaboo, you've definitely gotten the attention. The attention is here. So it's not positive attention. Yeah. So, all right. Elizabeth said, Emily, you have the, oh, let me clarify that down, Pat. I make no aspersions about what anyone wants to do with the back door. You just can't do it when you are the clerk of court letting people in past security with the courthouse. I cast no judgment on anything else. I do cast judgment on Becky Hill using her job for clout. Lots and lots of judgment. Also, can you imagine, like, the ego wanted to be stoked for Becky Hill and then to have to come out in court under oath and say you plagiarized your book? Come on. Are you not embarrassed? Oh. Let's continue on. They say the trial court nevertheless denied the motion for new trial by committing legal error. and by abusing its discretion. This is going through the standards that the Supreme Court is going to have to find to overturn the trial court's ruling and either grant further hearing or grant a new trial. The defense is trying to get the Supreme Court in South Carolina to grant a new trial. I think they're also trying to get the standard changed because that is their best avenue to a new trial. And they have reason to make that argument. There is a split here. This is not grasping at straws. This is a solid legal argument. So they go on to say the trial court abused its discretion when finding the jury's verdict was not affected by Ms. Hill's tampering, despite a juror's uncontradicted testimony. Again, the trial court found it was contradicted, but the state is going to respond to this down the road, so we'll get there. And then they're getting to the presumptions. We're not going to do all of those today because I'm going to start doing Q&A in just a minute, but they start getting to that standard that we've talked about, the difference between the federal standard and the state standard. And we will talk about that more when they file their next motion, because this is going to be refiled. And we're going to, here, let's do this one part because I think this is actually helpful. Let's see. They're saying that the trial court, Judge Toll, erred by ruling that South Carolina courts should disregard binding precedent of the United States Supreme Court that requires it to presume jury tampering is prejudicial to the defendant. This is the Reamer opinion. Excuse me. The U.S. Supreme Court held unanimously in Reamer, quote, in a criminal case, any private communication, contact, or tampering directly or indirectly with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial, which means the defense doesn't have to prove it, it's presumed, if not made in the presence of known rules of the court and the instructions and directions of the court made during trial with full knowledge of the parties. The presumption is not conclusive, which seems to mean it can be rebutted, but the burden rests heavily on the government to establish, after notice to and hearing of the defendant, that such contact with the jurors was harmless to the defendant. So the defense is saying this is what South Carolina should be looking at. And if this is what South Carolina should be looking at, then Murdaugh has met his standard. Then the state must show that it was harmless. So what the South Carolina Supreme Court could do here is say that the standard, I'm getting ahead of myself. No, I'm going to lose the thought if I don't. This is the other option here. The South Carolina Supreme Court could say, yes, Justice Toll used the wrong standard. Go back and do the hearing again, applying this standard. And then the Supreme Court is not granting or denying a new trial. They're remanding it for further hearing. So they could remand it for further hearing, saying, we have found that the standard applied was incorrect. Go back and apply the correct standard and rule again as to whether or not under this standard there should be a new trial. So instead of making the ruling, they could bus it back down, which actually might be what they do. They could bus it back down saying, this is the new standard, go make the hearing. You were the court that heard the original hearing. That actually might make more sense for them to do it that way instead of making the ultimate decision. And that's much more court-like, because they could, this is why we do this in real time, they could determine that the standard is wrong without granting a new trial outright and just granting a new hearing for new trial. That actually is probably more reasonable of what they will do. That's very, when I say courts take the road of least resistance, this is very like, piece it down. The court applied the wrong standard. This is the right standard. Go back and do it again. And then it puts it back. It puts it back in the hands of Justice Toll, and then this starts all over again. Moa said, would they have to testify again? It depends on what the court decides. So it really depends. Sock and Poupe said, make the new trial not as boring. I didn't find the Murdaugh trial boring at all. I think it did get a little long when we were talking about the fraud cases, but if there is a new trial, they won't get to go into that nearly as much because he's already admitted it. So I didn't think it was boring at all. So they go on to talk about the trial court's ruling that the green standard was the appropriate standard. The green standard is a 2020 case from South Carolina. Oh, what year is the Reamer case? Hold on. I need to know. Year. The Reamer case was decided in 1956. Huh. So if the Reamer case was decided in 1956 and the green standard that the court applied is a 2020 standard, then the court might have already taken this up. We'll see what the state has to say when they reply, but the green standard is not old. The Reamer standard is old. So the green case knew that the Reamer case existed and decided not to apply it. They're saying State v. Green directs South Carolina courts to ignore Reamer. The South Carolina Supreme Court said very clearly, we do not go off the guidance of the 1950s case U.S. versus Reamer. So the Supreme Court has already said that in green. So this gives them another opportunity to look at it, but it also gives them an opportunity to either reaffirm their position from 4 years ago or to change the position from 4 years ago. Harpootlian, we do not believe that's what Justice Kittredge, it's giving Mission Impossible. Justice Kittredge said in State v. Green, the court, he said it straight out as clear as a bell can be, but I've ruled on that. Justice Toll is just like, don't tell me what the judge did or didn't do. I've sat in that seat. I've worn that robe. Our Supreme Court, however, has not split with the Fourth Circuit to instruct South Carolina courts to disregard Reamer. In Green, our Supreme Court merely declined to adopt the Reamer presumption of prejudice in every instance of inappropriate bailiff communication to a juror, because not every inappropriate comment by a bailiff to a juror rises to the level of a constitutional error. This is exactly the kind of thing that the courts take up. The feds are doing it there. Our state is doing it here. There's some disagreement with what's going on, so we will take the opportunity to clarify it. And this really is why I think the South Carolina Supreme Court said yes. Instead of letting the appellate courts figure out what they think we might do, let us tell you what we might do. So here's the options before we move on to talk about the egg juror and then answer questions. After, Miguelina, we'll talk about this after stream, but after going through the defense's initial appellate brief on the issue of the motion for new trial, they are very clearly arguing that the trial court and Justice Toll got the standard wrong and that the standard applied by South Carolina splits from what the federal standard is to presume that any communication to the jury by state officials, like a clerk of court, like a bailiff, is presumed to be prejudicial, and then it is the state's burden to show that the communication was harmless. The defense is arguing that putting the burden on the defendant to show that it was prejudicial is the wrong standard, and the court should grant a new trial because the court applied the wrong standard, which leaves the South Carolina Supreme Court with a few options. One, they can say, you're right, the standard's wrong, have a new trial. Two, they can say, no, we said in the Green case in 2020 that this was our standard. Let us reaffirm our prior standard from the Green case in 2020. And this is what we mean by that, denied. No new trial, this part is done. Remember, Murdaugh still has an appeal running on other trial issues. This is just the motion, the appeal on the motion for new trial. Or the court could say, yes, we agree that the standard needs to be more narrowly defined. We take this opportunity to define our standard better, which I think they may do because they took this out of the hands of the appellate court and took it directly. So I think either way, they're going to take an opportunity to define what their standard is and how their court looks at this, and then say the standard is more clearly this. And with that guidance, we are not granting a new trial, but we are granting a new hearing. Take the standard, because the trial court did not apply this standard, take this standard that we are articulating and take it back down and do another hearing at the lower court and remand it for further discussion at the trial court. And that might be what they choose to do. It kind of sidesteps whether or not he gets a new trial. but it allows them to redefine their standard or more thoroughly define their standard, which if they didn't want the opportunity to redefine their standard or to clarify their standard, they wouldn't have taken this case out of the hands of the appellate court. Normally it would go to the appellate court, and then after the appellate court finally rules, after motions and the potentially year or years long process for appeal, it would go to briefing, and then it would go to oral argument potentially, and then it would get an appellate ruling. Then it would get, that appellate ruling would get appealed to the Supreme Court. The Supreme Court took it out of that procedure and shortcutted it so they could look at it directly. The only reason they're going to do that really is to look at the standard and to articulate it more fully. If they stood behind everything in the Green case or didn't think there was confusion there, they wouldn't have taken this out of the hands of the appellate court. They would have let the appellate court roll through on what the standard is. We'll see what they decide to do with all of that. But what we have next procedurally for the Alec Murdaugh appeal on the motion for new trial is the full defense briefing, because this briefing is not going to count. They're asking for more briefing. It's probably going to be the same briefing we've looked at, modified slightly. Then we're going to get the state opposition, then the defense reply. Then the state Supreme Court is going to decide if this goes for oral argument or if it's decided on the briefing. And then at some point in the future, we will get a ruling from the state Supreme Court and see what happens there. But while this is going on, Alec Murdaugh is still trying to appeal his 40-year sentence in the federal case. I'm going to pull that up real quick because when we looked at that federal plea deal, and I need to find where that federal plea deal is. When we looked at that federal plea deal, it was really clear that part of the federal plea deal was that you waived your right to appeal. So it's real interesting that he is trying to appeal it. So let me pull that up. There are so many Murdaugh cases here. Let's see, where is the plea? Nope. Thank you for indulging me one moment. Let's see. Remember the government made a motion to hold him in breach of his plea agreement? That was fun. They're like, no, we're done with you, Murdaugh. They were done with the murdacity a while ago. So let's pull up his government plea deal real quick, just so we all know that we're looking at the same thing before we talk about Murdaugh appealing his plea. Because the Murdaugh shenanigans are not done, Murdaugh is trying to appeal his sentencing in the federal case, even though he waived his right to appeal. We're going to take a look at that real quick. This is his plea agreement from September 18th, 2023. In consideration of the mutual promises, the parties agree as follows. Defendant agrees to plead guilty to counts 1 through 22 of the indictment. All of them. All of them. And then they go through all the counts. We went through this in other content, which is why I'm zooming, because we've been through this entire plea deal in its own video. But I wanted to get to the recitations. Cooperation and forfeiture. Defendant agrees to be fully truthful and forthright with federal, state, and local law enforcement agencies. Remember, they didn't think he was being fully forthcoming, and that's why they tried to revoke his plea deal. And the court said no. The defendant must provide full, complete, truthful debriefings about these unlawful activities and must disclose fully and provide truthful information to the government, including books, papers, documents, etc., etc. The defendant will not be permitted to withdraw his plea of guilty to the offenses described above. All additional charges known to the government may be filed in the appropriate district. The government will argue for a maximum sentence for the offense which the defendant has pled. The government will use any and all information and testimony provided by the defendant pursuant to this agreement or any proffer agreement in the prosecution of defendant on all charges. And that's what happens if this becomes void, right? If he's not truthful, that is what the government is saying that they will do. The defendant agrees to submit to a polygraph. The government agrees that any self-incriminating information provided by defendant as a result of cooperation will not be used against defendant. And that includes the polygraph that they required him to sit for. Let's see. The defendant agrees to voluntarily surrender and forfeit the property, any property that they can seize Most of that is already in a receivership, so there's not a whole lot there. Merger and other provisions. Where is the waiver of... It's here somewhere. The defendant waives all rights, whether asserted directly or by representative, to request or receive from any department or agency any records pertaining to the investigation. The parties agree that the plea agreement contains the entire agreement, does not supersede or supersedes any other promises, conversations. Let's see. Where is... The defendant is aware of the rights to contest a conviction or sentence, acknowledges those rights. The defendant, in exchange for the concessions made by the government in this plea, waives the right to contest either the conviction or the sentence in any direct appeal or any other post-conviction action. I don't know how much more clear that can be. I don't know why he agreed to this plea deal. This plea deal gives him literally nothing, but he agreed to this plea deal. He's mad about it. He directly waives his right to appeal the sentence or the conviction. And he's trying to appeal the sentence. He waived it. So he waived it. I'm out of Kleenex. Julie in the chat said, how did he appeal it then? Well, you file it, and then the government says, no, what you can't do is that. And that's what the government is doing. He's filed it, and the government's like, that's exactly hilarious. You can't do that. Let's pull that up real quick. I had that saved. Where is it? Give me 1 second as I grab a new tab for the murdacity of it all. Where did it go? Apologies for being less swiftly prepared. I normally have got things, well, not always, but we normally have things handled more. But being sick has really just absolutely thrown all of the things off for me. How bad is it? It's not great. It's not great at all. All right, let me do this real quick, and we're gonna grab what Murdaugh is trying to do this time because, Murdaugh. Oh, give me 1 second. I'm gonna put music on because I absolutely have to cough. Give me 1 second. Where'd my music go? What I loved about morning radio, they have a cough button where you can actually like put the cough button on so that if you do cough, it is immediately covered. It's brilliant. At some point, I need a cough button. Need my own cough button, but I just have a mute button and that works well enough. All right. Let's go take a look. I actually jumped the ones I thought I was going to grab. We're going to skip Murdaugh's because what I had picked up was the government's response. So we're going to look at the government's response real quick because this was more recently filed. This was filed August 8th. So let's look at the government's response real quick. Murdaugh is trying to appeal his 40-year sentence in the federal plea deal. We just pulled up the plea deal that says what you can't do is appeal any part of this. What Murdaugh is trying to do is appeal his sentence, and the government responded. If you guys are interested in me continuing to cover this part, just let me know in the comments and in the chat that yes, you want to cover all of the post-trial shenanigans that are Murdaugh. This is the United States of America versus Murdaugh, appellee's motion to dismiss appeal. Appellant, Murdaugh's appeal must be dismissed. Right. Murdaugh entered into a knowing and voluntary appeal waiver, and his challenges to his sentence fall within the scope of the waiver. Footnote 1. Under Local Rule 27A, the undersigned informed Murdaugh's counsel at the time the United States would move to dismiss. Counsel objects. Background. Murdaugh was a personal injury attorney at a prominent law firm in Hampton, South Carolina. For more than 15 years, he spun a complex web of exploitation, manipulation, and deceit. Wow, the government's just like, For more than 15 years, he spun a complex web of exploitation, manipulation, and deceit, preying on highly vulnerable victims in pursuit of his own financial gain. He stole over $10 million from 27 individuals and his law partners, and he laundered over $6 million in stolen funds. The Murdaugh crimes. As a personal injury attorney, Murdaugh represented individuals in civil claims following injury, death, and other loss between at least September 2025. No, Emily, we are not traveling into the future. Between at least September 2005 and September 2021, he devised and executed a scheme to defraud and obtain money owed to both his clients and his law firm. The scheme evolved over the years to avoid detection and to capitalize on every opportunity to increase Murdaugh's ill-gotten gains. They're like, oh, you're going to try to get out of your 40-year sentence? Let me tell you why you deserved more than 40. He drafted and directed law firm employees to draft paperwork diverting settlement funds to his personal bank accounts, claimed funds that were held in the law firm's trust account to satisfy liens on his client's settlement funds as attorney's fees, and then directed the disbursement of those funds for his personal benefit. Girardi claimed and collected attorney's fees on fake or non-existent annuities, created fraudulent expenses not incurred on client matters, and directed the disbursement of settlement funds to pay the fake costs, including claimed medical expenses, construction expenses, and airline expenses. Remember to go to a football game? Directed other attorneys to distribute attorney's fees directly to him, intercepted insurance proceeds intended for beneficiaries, and then deposited them directly into his own personal bank account. Fake forge. In another scheme, Murdaugh owned and controlled bank accounts disguised as accounts for Forge Consulting LLC, a company that specializes in brokering structured settlement. My brain read that all wrong. That specializes in brokering structured insurance settlements. He used those fake Forge accounts to hide the source and designation of his stolen funds and to funnel millions into his pockets. He then laundered the money by making cash withdrawals, transferring funds to other personal bank accounts, making credit card payments, and issuing checks to other people. He also exploited his position in the community, the power of his law firm, and his personal relationships, using his influence to enlist others to facilitate and conceal his crimes. One scheme began in 2011 where Murdaugh started recruiting personal friend and banker Russell Lafitte to serve as a fiduciary for some of Murdaugh's most vulnerable clients, Hannah and Alina Plyler, Natasha Thomas, Hakeem Pickney, and Arthur Badger. The Plyler sisters had been injured in a car accident that killed their mother and brother. Thomas was a young girl recovering from severe injuries sustained in a car accident. Pickney had passed away after being rendered a quadriplegic in the same accident. Badger was left to raise 6 young children after burying his wife. Lafitte extended Murdaugh nearly $1 million in loans from the conservatorship Lafitte managed for Hannah Plyler. And together, Murdaugh and Lafitte stole over $2 million in settlement proceeds from Thomas, Pickney, and Badger. They used the money to pay back Hannah Plyler, pay Murdaugh's personal debts and expenses, and provide gifts to family. Footnote 2. Lafitte was sentenced to 87 months in prison for his role in the scheme, judgment, and then they list the case. His appeal is set for oral argument on September 25th, 2024. He is still facing related state charges, and then it lists all of those. Let's see. In a separate scheme, Murdaugh and his close friend and fellow attorney, Corey Fleming, stole from Pamela Pickney, Hakeem's mother. She was badly injured in the car accident that rendered her son a quadriplegic. From 2012 to 2017, Murdaugh and Fleming diverted her settlement funds to enrich themselves, including by chartering flights to the College Baseball World Series. In 2018, Murdaugh and Fleming conspired again to steal from other vulnerable victims, the children of Murdaugh's housekeeper, Gloria Satterfield. Satterfield fell at the Murdaugh home and died shortly thereafter. Murdaugh convinced Fleming to represent Satterfield's sons and sue Murdaugh to recover a homeowner's insurance policy. Together, they lied to the Satterfield sons, the court opposing counsel, and the insurance company, and falsified settlement documents. In the end, Murdaugh stole more than $4.3 million from Satterfield's sons. They did not get a penny. Note, asterisks, hold on. Note, they have since been recompensated by the lawsuits against the other entities that allowed this to happen. But the 4.3 million stolen from insurance, they have never gotten. They have been compensated, but they never got that money. That money went directly to Murdaugh, and he has not recompensated his insurance. So insurance is out that money at this point, which is why insurance is suing Murdaugh over that money. So that's the kind of asterisk on that, because not all of his victims have gotten paid. So I will try to point out the victims that have gotten paid, even though they did not get paid by him. And a lot of damage was done before they got paid. Murdaugh's schemes unraveled in 2021. See, the pandemic did quite a lot to bring some of these schemes to the surface, because it slowed down, like the Ponzi scheme of the more money coming in to bolster up the whole scheme. When the courts slowed down, it slowed everything down. And I think that's why we saw some more of these cases bubble up to the top. It said, or bubble up to the light. On June 7th, a law firm employee confronted him about missing funds in one of his cases. That night, his wife and son were brutally murdered. By September, the law firm realized Murdaugh had been stealing from client trust accounts, and in October, the state charged him with 139 counts related to his thefts. In July 2022, the state charged Murdaugh with the murder of his wife and son. A jury found him guilty in March 2023. He was sentenced to 2 consecutive life terms. Federal indictment and plea. In May 2023, Murdaugh was indicted on 22 federal counts. And then they list the 22 federal counts that we've already gone over. Murdaugh entered into a written plea agreement with the government. Murdaugh and his counsel and the prosecutor signed it. Murdaugh, the lawyer, and his counsel and the prosecutor. The government agreed to recommend Murdaugh's sentence be served concurrently to any state sentence for the same conduct. In exchange, Murdaugh agreed to fully cooperate with the government and partially waive his appellate and post-conviction rights. The relevant portion of the waiver states, we've already read that earlier. And then they go through the federal and state guilty pleas. The court confirmed that Murdaugh was satisfied with his attorney's representation, that he had enough time to discuss the case with his attorney, and had no complaints regarding his counsel. It reviewed Murdaugh's constitutional rights and the rights he would be giving up by pleading guilty. Like, if anyone knows the rights you're giving up by pleading guilty, it's a man who's acted as a criminal defense attorney and a criminal prosecutor. Like, he is well aware. Like, he is well aware. Murdaugh told the court that no one had threatened him to plead guilty and that no one had promised him a specific sentence. He affirmed that he was pleading guilty of his own free will because he is guilty. The government summarized the plea agreement. It explains that agreement contained a particular appeal waiver, and then they go on to cite the appeal waiver. The court highlighted the waiver. Every defendant, so he's been told about it 4 times in court. Every defendant, including one who pleads guilty, has a right to file an appeal or seek post-conviction relief regarding the conviction and or sentence. You're partially waiving that right. You're retaining the right to file an appeal related to prosecutorial misconduct, ineffective assistance of counsel, or future changes in the law that affect the lawfulness of your sentence. Otherwise, you are waiving your appeal right. Murdaugh told the court he understood. Let's see. Federal sentencing. Murdaugh's pre-sentencing investigation report calculated an advisory guideline range of 210 to 262 months. The court issued a notice that it may consider an upward variance. I lost my mind over that. When the court's like, yeah, they recommended that, but that's not enough. Like, you deserve more. More. Normally you see federal courts, especially on what are theft crimes, nonviolent crimes, you generally see the court downward departing, going, yeah, but this court was like, nah, we're gonna upward depart. We're gonna go up. Murdaugh appeared for sentencing in April 2024. The court began the hearing by confirming Murdaugh had reviewed the pre-sentencing report and discussed it with his attorney. It overruled Murdaugh's lone objection and adopted the PSR's guidelines. Murdaugh's counsel argued that Murdaugh was being sentenced for essentially the same conduct that he'd already pled guilty to in the state, and that federal charges were the result of a turf war between the Attorney General of South Carolina and the United States Attorney of South Carolina. The court disagreed, explaining that each sovereign had a right to make a statement regarding the conduct of the defendant, which he has admitted to. Counsel then argued that in other cases involving losses greater than $10 million, the defendant's like Sam Bankman-Fried, Jeffrey Skilling, and Elizabeth Holmes, received sentences between 11 and 25 years. The court noted that counsel had left off a case, Bernie Madoff. The court's coming in hot. This is more info than we've gotten about the sentencing in a minute. The court says, excuse me, counsel, you forgot a different fraudster. You forgot somebody. You forgot Bernie Madoff, who was sentenced to 150 years. Counsel argued that Murdaugh was 55 years old, had over 20 years left to serve on his state financial crimes, had accepted responsibility for the financial crimes since he was first confronted about them. But the court countered, But the court countered, he committed 15 years of fraudulent conduct. This is the first time we're seeing the court quoted. But the court countered, he committed 15 years of fraudulent conduct. He stole from 27 clients, some of them the most needy, vulnerable human beings. One was a paraplegic. They were motherless children. They were widowers. The court continued, I've seen the disgrace he's brought, not just to himself, but to his law firm, to his country, to his county, to his state, the judicial system nationally. Those are all factors to be considered. The court was just like, shame on you. You're disgraced. You've brought disgrace, and you stole from the most vulnerable who trusted you. No. The court didn't call him subhuman, but that's kind of where they're going on that. Could the court say that? Probably not. Defense counsel asked for guideline sentence to run concurrently with the state sentences for his financial crimes. Murdaugh addressed the court, expressing that he used opioids to hide from the things that he was doing to the people that he cared about, and that his addiction contributed to him doing some of the things that he did. It's just like, but I was struggling. He said he knew what he was doing was wrong, and he was committed to improving himself. He told both the victims in the court and the court that he was filled with remorse and guilt. In response to Murdaugh's comments about addiction, the court said no truly impaired person could pull off these complex transactions. Oop. They are very complicated, and using his undoubtable charm and charisma, he persuaded all kinds of people to do things they should not have done, and in furtherance of his pursuit of countless amounts of cash. No, Murdaugh, you're not an addict. That's not what accounts for this. The court literally said, you are a greedy liar, you defrauded people, you coerced people, and you've been convicted of killing people in the name of greed. The court again emphasized that the victims were among some of the most vulnerable people we could imagine, that these were people whose lives had been turned upside down by a collision or a wreck or some other tragic event, and they placed their problems and all their hopes in Mr. Murdaugh. And it's from those people he abused and stole. And you can see where the judges are offended on a different level by the lawyers doing this. Like, the judges take their profession seriously. The judges take the ethics seriously and are horribly offended. And this is what's going to happen when Girardi is convicted. That the judge is going to be like, you have disgraced yourself and your profession by stealing from those who turned to you when the worst had happened to them. It's disgusting. This isn't someone stealing to feed their family. This is someone stealing from families who need to be fed so that he could take a private jet to go watch baseball. You're not the same, Murdaugh. And the court's just like, no. The government argued that the nature and circumstances of Murdaugh's offensive really cannot be overstated when you look at the complexity of his scheme, the vulnerability of the victims, the abuse of the position of trust, the different ways that he was able to perpetrate and carry out his scheme by bringing in others to make sure he was able to achieve his ultimate goal, all for his own enrichment. And then they go on about the sentencing. He was sentenced. The government requested a 30-year sentence, the statutory maximum on counts 1 through 4. The court responded that 30 years was not actually the statutory maximum. Oh, can you imagine Dick and Poot sitting in federal court where the government says, Your Honor, 30 years is the statutory max. We would like 30. And the court looks down from the bench and goes, well, actually, hold on. Well, actually, 30 years is not the max. We can go for more. Murdaugh knows what's happening. His stomach must have fallen out his ass when the court is like, well, actually, because they're still banking on something happening with the murder convictions, and they wanted this conviction to be less than the 22 years for the state. The court responded 30 years was not actually the statutory max, and the government recognized that. Although the court could stack sentences, 30 years was sufficient but not greater than necessary, in part because at 55 years old, 30 years is a death sentence, so to speak, and that's, of course, taking into account he's already serving 2 consecutive life sentences for the murder of his wife and son. The court sentenced Murdaugh to 40 years in prison. I have never seen a judge look at a theft case, look at the government asking for 30 and go, bet we're going higher. It's incredibly unusual. I said this when it happened. The court sentenced Murdaugh to 40 years. It imposed a 30-year sentence on 4 counts, a 20-year sentence on 4 counts, and a consecutive 10-year sentence on the 14 money laundering counts. It directed the sentence to run concurrently to the state sentence, ordered Murdaugh to pay $8 million plus in restitution, $10 million plus in forfeiture. Good luck to the government in recovering those funds. The court called the conduct reprehensible, systematic theft from clients, and then goes through the 40-year sentence. Here's the thing. Where's their conclusion? He waived his right to appeal. Murdaugh knowingly and intelligently waived his right to appeal. Yeah. The government summarized the plea agreement, including the appeal waiver. The court reiterated the effect of the appeal waiver, confirming with Murdaugh that after entering a guilty plea, he retained the right to file an appeal only if it related to prosecutorial misconduct, IAC, or future changes in the law. He confirmed the understanding of the waiver. So the government's like, Your Honor, no, we're not doing this. We're not doing this at all. They go on for another 10 pages about it, but essentially the government is like, here, we'll go to their conclusion. Murdaugh's appeal waiver is valid and both of his claims fall within its scope. The United States requests that the court dismiss the appeal. That's it. That's it. And for all of you in the chat saying 40 years is a lot, yes, Elizabeth Holmes got less, Sam Bankman-Fried got less. The position of trust is a huge part of this for the court. We have one last thing to talk about because books are always a good idea. So we have one quick last thing to talk about and then question. Because then my brain is going to stop. My brain is going to stop functioning. But I saw this reported. I didn't think it was true. It is in fact true. I don't know how I feel. Chat, I want to know how you feel about this. But the egg juror has a book. Why? Why? I'm going to put up a poll. I'm going to start the poll and then I'm going to talk to you. Hold on for a second with the poll, but I'm going to put up the poll and then talk to you about this. Is this book a good idea? I'm just asking, is this book a good idea? Yes or no? All right. It doesn't mean you don't want the tea. That's separate, but is this a good idea? Yes or no? The egg juror who was dismissed in the middle of trial, and the egg juror's lawyer, by the way, is fighting to get all the transcripts released. That's a story for a different day. But the egg juror, all up here on the Facebook, yes, the photo of the egg carton is the Facebook page photo. Juror 785, because enough is enough. This is the book. South Carolina Supreme Court, that's breaking news. Let's see. Alec Murdaugh's back in the news. Pre-order an autographed book today by Alec Murdaugh, Juror 785. So this book is going to start shipping apparently later this month. We'll see. But We have a tentative date for the book release on Tuesday, August 27th. And apparently the book cover says because enough is enough like 3 times. A tell-all book, how Juror 785 was wrongly kicked off the jury at the Alec Murdaugh trial. Why? Juror 785 is fighting to get all the records unsealed from all the hearings, and try to get the hearings that happened in camera and behind the court unsealed to see what's going on. Okay, this meme's actually kind of hilarious. I'm not mad at that. I'm really not mad at it. What music is this, and is it going to be a problem? Wrong music. I'm not here for that music. I'm absolutely here for that meme. But there's a whole I think this is a terrible idea. But there is a book, Because Enough is Enough, a tell-all about the rigged Alec Murdaugh trial. So you know that this tell-all is going to further complicate shit. The egg juror, who again has not identified themselves by name, which is always interesting. If you're writing a book, to not identify yourself by name is a choice. But this is going to continue. This is going to continue to cause problems. It's going to cause problems. So another book, More Money, More Problems, is where we're at. This is a terrible idea, but if everybody else is writing a book, because there's another book coming out, Valerie Bauer-Allen has a book coming out, and we know that this was rushed to be the first book out. We know, I don't even know where my other, I need my prop books all together, but I have Mandy Matney's book here somewhere. Valerie Bauer-Allen is releasing a book on the Murdaugh case. And so I have seen quite a lot of press about that book. She was one of the in-court reporters, reports for the Wall Street Journal, and is releasing, what is it called? The Devil at His Elbow, Alec Murdaugh, The Rise and Fall of a Southern Dynasty. So for all of you that are like, okay, but we need a book, I don't know. For me, it's well taken from Mandy and from Valerie. They were both intertwined in this story. I'm interested to hear what Valerie Bauer-Allen has to say about being at Moselle and being the journalist that was selected to go to Moselle. I'm interested, but at this point, it's just wild. For those of you in the chat, like, everybody should write a book. I'm definitely not writing a book about covering the Murdaugh trial. When I write a book, it will definitely be about something else. It's not going to be about this. Maybe about what I do, but definitely not about Murdaugh specifically. Murdaugh is a part of the larger story here. But Valerie Bauer-Allen has a book. I imagine it's going to be incredibly well written. I like her writing. I liked her reporting during the trial. So, books for everybody, apparently. But the egg lady juror book, also to not disclose identity and write a book, is a wild choice. But the egg lady juror has things to say and wants to tell their story, and okay, sure. It's going to be interesting. It's going to be interesting. Carrie said, I'm going to write a book called Watching EDV Cover the Alec Murdaugh Books in Trial. How is she going to autograph it without her books and names? She's just going to sign it egg. Just egg. So there are some books that I'm interested in. This is not one of them. Will I get it for the stack of ill-advised books? Probably. Will I go through it for you all? Probably will. But at that, we should get to questions. Emily's brain has stopped working, so we're going to do some Q&A, and then I'm going to, go back to bed. There is a new podcast tomorrow for you. So that will be out tomorrow, going over everything that's going on with the Matthew Perry prosecutions. So tomorrow's podcast, 11 a.m., we will notify you in the app, and that will be in the app. So for those of you asking, so the chat should not buy and send. No, do not send me this book. I do not want multiple of you buying it. I will handle it. Do not buy and send me this book. You guys send me great books, not this one. I don't need this one. I'll take care of it. We will do it for work. I will do it so you don't have to, and we'll go from there. Just woof. I need to go gather all the books together and just have a shelf of all of the books related to this. Is this Becky's second book? No, I really do think this is from that egg juror. They co-authored it with somebody. I don't know, but we'll see. The egg juror seems to be mad that they were yeeted from the jury. I don't think it was wrong, but I am interested to see if their lawyer is successful in getting all of those ex partes unsealed. That I will absolutely cover. We will cover all of it because I'm curious to see what happened. We've seen some of it, but I'm curious to see what happens if all of those are unsealed. I don't know if I'll get to all of the questions. I'm going to do my best. Let us go to your questions. My brain is tired. So for all of you who sent the members only chats, thank you. I see them. Thank you for the well wishes. J. Michael, good to see you. It isn't fall until pumpkin spice. Oh, what? Soon? Yeah, like this week. This week then. This week is fall. So thank you for all the well wishes, y'all. I know so many of you have been sick this fall. It just is what it is. Lori said having trial day withdrawal. Next week, we're back for a preliminary hearing. I just don't know if it will be streamed or not. I probably need this week to recover. So it's probably good that we don't have preliminary hearing this week. We'll be back in court next week in some way. We'll figure out how we do that down the road. I really hope that the court allows for streaming of it. There was a lot of confusion at the last hearing in Utah. G. Lander said, Elvis is in the building. Elvis is in the building. I was really curious about that. So George the Cat said, is the bump reference you made from the Adina Howard Freak Like Me song? No, it is a Reno 911 reference. If you've seen the meme going around of Reno 911 doing field sobriety test, it's a bump, bump, bump. So that's what it is. So let us continue. One Way said, love your sick voice, EDB. Thank you. I don't always love my sick voice, but we are here. It is. Alexis, what happened with the Scientology Leah Remini lawsuit? It is moving along. There's a lot of litigation to catch up on, but we will be updating on it soon. It's on my docket to circle back to. Emily, 3 years. What a wild ride. I know. And thank you for being here. It's wild. For those of you asking about Sarah Boone, it's gonna depend on time. Some of the Sarah Boone, if Sarah Boone starts on time, it's gonna conflict. So I will figure out as we get closer, because every time Sarah Boone's in court, she's saying, I'm just not prepared. The court seems like they're like, I don't care. We're going full steam ahead. This trial's taking forever. I don't know if Sarah Boone's gonna go ahead on time, but I will figure out how and when I'll be covering it. But it's gonna fall right during some of the fall break I have. So we'll see. I'll keep you guys posted. We will find a way. It's just going to depend on that. Daniela asked if I'm covering anything Scott Peterson related. I talked about Scott Peterson this week on Quick Bits. So if you have not listened to the Quick Bits podcast yet, it's on the podcast feed. It's also on the Quick Bits YouTube channel. We notify about that in the Law Nerd app too. I covered the updates this week, and I did a podcast on that here on this channel a few months back. So yes, I have been keeping kind of updates. I'm doing the larger updates on that. Like, this is what's happening, not a filing by filing update. There's not a lot we've actually had time to do filing by filing updates on because it's just been so busy with trials. So Rachel Mills asked, will we cover the charges for the Matthew Perry case? Yes, tomorrow on the podcast. The Great Big Geek said, in the same vein as the TikTok case with the popularity of J.R. Blanchard's reality series, there's psychics allegedly contacting Dee Dee saying that she did. I don't know what that is. Do you think she will sue them like the teacher did? The Great Big Geek, I have no idea. I have no idea what. I have no idea. But when it comes to Gypsy Rose, because there is a conviction there, it's a little bit different because she was convicted. So there's some differences when we talk about defamation post-conviction, very different than the TikTok psychic case because there's no arrest, no conviction, nothing like that. So it's a bit different situation. Jen S. said, I was so excited to hear you on Mix 104.1. I said hi via the text line. Thank you, Jen. It was really fun. I love radio. I really do see a lot of what I do here is just like interactive broadcasting. So it was a thrill to be in studio with Carson and Kennedy. It was a lot of fun. It was just a lot of fun. This is Rolling Along, said she wanted fame but found infamy. Yeah. Courthouse Becky was shooting for fame, shooting for being like America's courthouse sweetheart and missed a lot. So there's that. Let's see. Aiko said, will you cover the Mr. Beast allegations? Aiko, I don't even know where to start. There are so many things going on. A lot of you are interested. I'll put up a poll in the member space. I don't know how interested people are. I mean, if I was going to talk about anything in the law sense, the illegal lotteries stuff, but taking 3 days to go to Boston and see the Law Nerds and do the NKOTB stuff, there is breaking stuff in the Mr. Beast of it all daily. There's stuff ongoing with a TV show. There's stuff with employees. There's stuff with lotteries. It's so much stuff. It's not going to get put in line. Here's what I will say. Mr. Beast is not going to skip the line on all the other cases that I need to catch up on because it's just not a top priority. But if you guys are interested, maybe we'll talk about it in the members only and we'll go from there because it's tough. Music to My Soul said, if the Juror's book jacket doesn't include a review calling it excellent, then I will be very disappointed. It's a very, very good point because that's hilarious. But it would be very funny. Madre said, I think he accepted the plea trying to serve Fed. Madre, I think what you're trying to say or what you are saying truncated is that he wanted to serve in federal prison. It was clear, though, in the plea deal that it would be concurrent with state time and that he was going to be serving concurrent with state time. If Lucas said, can you please live react to the South Carolina Supreme Court, because it's not the U.S. Supreme Court, the South Carolina Supreme Court, if they are audio feed, we will cover it. If he gets oral argument, once everything is done. So Julie said, may we get a ranking or tease ranking of this year's DCI shows or just his favorite ones? I will ask him. I know he really enjoyed Phantom Regiment's Cubes. The sound for both Blue Devils and Blue Coats was amazing. He always enjoys Troopers and Cavaliers, but I will ask him what he thinks. So who did the Prometheus show this year? My brain has stopped, but the Prometheus show, both of us really enjoyed. And I don't remember who did it. Can I Google it? Well, maybe. Carolina Crown. Yes. Sorry. It was called Promethean. It was really good. Thank you all. Chat's like, Crown did it. It was a great show. It was probably one of my favorites. I really enjoyed it. I loved the storytelling of it. I thought it was really fun. So it was interesting. So that. Some of you are just like, don't give a shit about Mr. Beast. Some of you are like, I just want the tea. And I wouldn't, if we were getting into anything at this point, it wouldn't be tea. It would just be the law side of it. But we've got a lot to get through before we get to the law side. Our docket is really full. And when I look at the calendar for this week and next, there isn't a lot of time to catch up because we have Corey Richins going to prelim next week. And then, let me see. I'll tell you why. Tell me why. I'll tell you why. Corey Richins is going to preliminary hearing next week. And that's going to be a very busy week. The Kohberger change of venue hearings are coming up. So next week, we've got a change of venue hearing and the Corey Richins hearing, which means we need to cover the Kohberger stuff like Thursday this week so we can do the hearing and be ready for the hearing next week. Maybe it'll go on the podcast. I don't know. But that's the end of August. Like, August is out, folks. And then we start getting into the Donna Adelson trial. And I've got some travel to New York right as the Donna Adelson trial starts. So it's going to be a very busy couple of months. And then in October, if Sarah Boone does go to trial on time, then Sarah Boone will be starting. And so we're going to have to figure out how to cover Sarah Boone while also maybe jury selection will take a little bit of time, fingers crossed. And then we'll cover Sarah Boone in August or in October, excuse me. And then it's November. And then it's November. So, and then the courts are like, we're not going to trial. So we've got quite a lot going on. I will be breaking it down. Do not worry. Thank you for being here, y'all. I appreciate you. Nordic Sims, I did cover Paul versus CoffeeZilla. That I was actually really interested in. The fair use, the is this defamation cases, always very interested in. So that I did break down and it's there. So with all of it, you guys, we have a very busy docket coming up next week. I will keep you posted on what we're doing Thursday. Tomorrow, we've got a new podcast episode for you. You're not going to see me around social because I'm going to go rest and try to not get worse as the week goes on. Thank you for being here. Thank you for all the well wishes. You guys take care of yourselves. Look, it is the season for pumpkin spice and everything nice and, cold, flu, COVID, and the rest of it. So take care of you. It's good to see you. Thank you for being here with me, and I will see you in the next one. Bye, Law Nerds. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.